In new business, we got in the information pack, and I told Mr. Solomon I would bring this to the attention of the board. If you didn't have a chance to read it, he requested that we read his submission about the proposed North Street roundabout. This is scheduled for this board next month.
May 13th.
May 13th, Bob Swanson will be here, and Mark Resnick. I don't know if the planning board is coming, or planning board will be here, and Mr. Solomon and the residents have been, I think, alerted that this issue's coming up. So I promised him I would ask that it be put in the information package, and if everybody can read it, review it before that meeting, I would appreciate that. We have Serenading Seniors is celebrating their 10th anniversary on May 14th at 11:30 at the Senior Center. Can anybody make that? May 14th.
I'm gonna have to wait till we get a little closer, Jimmy.
Okay, I can't. I'm working that day. I can't be here. Mark, 11:30 on the 14th.
I
on the
can't do
seniors.
any more days.
We always enjoy hearing the series.
Doesn't look like we're going to be there. Paul, if you can make it.
My
Yeah,
schedule.
I'm similar to Linda. I'll have to wait.
I have to wait for this, yeah.
We got a memorandum from Gellerman and Bushman on the dog park warrant article, and my reading is the town council has given us opinion that maybe it's legal and maybe it isn't. That's my reading of it. So I don't think that question's settled. You're free to read it yourself, and if you come to a different conclusion, bring it up to me next week. But I don't find anything in here that answers the question that we asked.
Which question?
I concur with that.
I think that Andy submitted a question whether or not we asked this office to review the legality of the proposed dog park warrant article. And town council goes on to say, I think, maybe it's not legal, maybe it is. So I would ask you to read it between now and next week. If you come up with a different interpretation, maybe we can talk about it. We talked about creating a list, I'm in old business now, if you don't mind, of executive minute
I haven't
meetings.
got to it.
It's in my folder, Andy.
Sure.
I'll keep that there. Foxboro Cable Access has invited us on Saturday, May 3rd at 11 o'clock. Is there anybody going to be able to go to that?
I will be there.
Bob will attend that. So Paul, we're 2 out of 5. No, three won't have a meeting, right?
Not me.
Is that enough?
Did that. I don't know if the board is aware that we had an issue on the payment of fees for the Larry Koff report that went back with the stadium sometime. We had discussions back and forth with the Patriots organization, and the Patriots organization, in fact, did send us $15,000. So that was, as far as I was concerned, part of our agreement, and they did honor that part, and we're all square with them, and that went for this year's appropriation. We could spend that money, right, Andy?
Well, it'll get certified for next year.
It would be part of free cash.
Free cash.
Okay, that's all I had for new business. Anybody else? That was my new business and old business. Mark?
I don't know if you want to call it old business, new business, but we have a police report in front of us about an incident at the dog park. Have everybody had time to read it?
I saw it here. I don't know what it's part of a submission that somebody gave us on dated April 22.
Yeah, I put all the packet of information together for the board members, and they had Chris email it.
I guess my question is, why are we have police reports written all the time. Why does it have anything to do with us?
The opposing attorney Valenzuela, who is the attorney for the abutters that are taking the town to court, was very proactive in causing a situation down there that involved the Foxboro Police Department and was very upsetting to a lot of people in town. And,
Well, who called the police?
The monitor.
And the police responded?
Correct.
And police wrote a report? Mm-hmm. Okay.
So, my question is the board going to stand by, or should we... Basically, I would like Sam Perkins to comment on this, if we could let him. This whole situation is getting more upsetting. It's involving now the police department. I expect it to continue, and how do we handle this? If the board's gonna always look for ways to control the dog park, how can we control this from happening?
Andy, who has jurisdiction over the police department? Chief O'Leary?
Chief runs the department.
Does this board have any authority to tell the chief how to run the department?
Not day to day, no, but I
Okay,
mean,
so I guess what's your question, Mark?
Well, I can't see that an attorney can go down there and act like this and represent his clients. I find it very upsetting, James, that he can go down there and pull this off and basically tell public volunteers that they're violating civil rights and every other thing that went down there. If you read the report, I mean, I can read it publicly right now. I'd rather that I asked Sam to comment on this. I mean, I think there's legalities involved here.
I'd be very interested in hearing Attorney Perkins also.
Well, let's pose a question to him to be answered then. What's the question?
The question is, should an attorney Valenzola be representing these people after reading this police report and the antics that he pulled down there?
Okay, can you answer that question?
I can answer that question. I'd also request that the board hear a recommendation, which I have, because I think that what happened last Thursday is directly relevant to the litigation that's going on. It raises problems that raise questions about what Judge Long's order says and doesn't say, because Attorney Valenzola, according to his own letter, not just the police report, made a bunch of representations when he and some of his clients went to the dog park about what Judge Long's order means and doesn't mean. Representations which I don't agree with and which I'd be very surprised to hear Judge Long agreed with. I think it also raises the issue of if, in fact, there are going to be ongoing questions about what Judge Long thinks are appropriate rules and regulations for the dog park in light of his order, which set out at least a minimum set of regulations. The simplest way to avoid incidents which come close to being a breach of the peace, which I understand this one was, the easiest way to avoid those is to simply go back to Judge Long and say, do you agree with what Mr. Valenzola has said? Do you agree with the current set of rules and regulations that have been adopted by the Conservation Commission? And I would hope that that would be a way to preempt a series of these incidents, because if history is any guide, I see no reason why Attorney Valenzola and his clients wouldn't be back there with fishing poles next week, or with some other way to test whether the current rules and regulations, to the extent that they don't just verbatim quote Judge Long, are actually acceptable to Judge Long.
There you go. Counsel suggested he'll file a motion to get clarification from Judge Long as to whether or not what went on is within the parameters of his order. Right?
Yep.
Okay.
Do we have to vote on that?
No, he's an attorney in a lawsuit is going to take a position that in order to defend his clients, he has to bring this motion, correct?
I think that that is the quickest way and the easiest way to solve the problem of to what extent can the plaintiffs continually test what the proper rules and regulations are.
We'd be plaintiffs or anyone. I mean, we're not. You don't mean to exclude everybody else in your motion, correct?
Correct.
You're going to get a clarification from Judge Long as to who can use that park and who can't, and under what circumstances.
Sounds good to me.
I mean, is that? I'm trying to paraphrase what I'm hearing, so that we.
What I would propose to do is to take the current set of rules, regulations, and signs that have been approved by the Conservation Commission and, as I understand, put into effect by the dog park operators and monitors, and ask Judge Long whether that's consistent with his rule.
Would you at the same time bring back to Judge Long the other complaints relative to the putting up of political signs, the posting of on town property for certain votes to be made? Are you going to bring all of that in front of him, or do we expect that the plaintiffs are going to do that?
Well, I think we need to take it one step at a time. I mean, you've seen Mr. Valenzola's letter of this morning, which he delivered, which I think tries to take virtually everything that's happened in town since the dog park opened and characterize it as a civil rights violation. I don't see that someone posting a sign anywhere in town that might be an inappropriate political posting and should be taken down is a subject for the land court to get involved in. I think that's something which the town apparently has already taken care of by directing that the signs be taken down.
Are you suggesting that you want to have political signs put up?
I'm suggesting that there are a number of issues that are raised that I tried to read in the interim here during the sewer proposal. I hadn't seen it until it was on the desk here. Is this getting worse? Is this problem getting worse, Council? What's happening here?
I think it's probably a little outside my purview to talk about whether a problem's getting worse or whether it's getting out of control. I do think it's clear that the plaintiffs and their attorney, which is quite an unusual thing for a lawyer to do, have decided that engaging in civil disobedience to test whether or not the rules are acceptable or not is something they've done once within days of when the dog park reopened, and it would, I think, be naive not to think that those tests might continue unless we get a clarification. There are other issues, obviously, that they've raised, including political science. I don't see those being implicated in the operation of the dog park or the question of whether it's a permissible use of conservation land. Those are the issues before Judge Long.
So you have, in your mind, an understanding of an appropriate solution, and it addresses Mark's concern.
As I've described, yeah.
Okay. Anybody?
Basically not to drain the municipalities from being pushed and have to, the police department can't be responding to all these situations down there. If there's other things and people to protect in this town. If they're gonna drain the municipalities, ongoing back to my comments I made a month ago, which has come to fruition. So this is my situation. It's what it very concerns me that they're gonna go at this point to do this, and that's why.
This board voted to approve the defense. We hired, through our insurance company, this attorney to represent us. This is a matter of litigation. And the attorney has given us his advice on how to respond to the issues raised by the Attorney Valenzola letter. Why would we expect anything else? I mean, if it's a...
I thought as a board we had to vote to allow him to do what he just suggested.
Is that your take on your representation of us? We don't vote to tell you what to do, correct?
I think we're now getting into the question of when an attorney can do something on his own initiative and when he should consult with a client. Always a good idea when new and dramatic events occur, and these from the 17th and today's letter are certainly new and dramatic events. Always a good idea to consult with a client. That's why I'm here tonight.
Do we agree that this board decides whether to prosecute, defend, or compromise in consultation with the town manager?
I, for one, I appreciate your coming out tonight and also sharing the information, including the email communications. It helps me better understand some of the give and take that's going on. And I also appreciate the opportunity to ask you some questions relative to the incident that happened at the dog park. And I think we all have to agree that it's a good idea to have an open line of communication with the attorney that's representing us. So I think we should all just take a step back, appreciate the information, and I would suggest that this board take a general affirmation that we support the direction that he's going in taking this next step. And I've read the response, I've read the activity that happened, I had heard anecdotally what had happened, and it's very concerning. I think our police department is unfortunately going to be called down there time and again to deal with situations. It's unfortunate that our volunteers, our volunteer monitors working on behalf of the Conservation Commission, were put in a position where their authority was questioned to the point where they had to call down the police department. But the system worked. The monitors were there. The police came down, enforced the regulations, and now we have an action, and now we're going to do a response. And so I think when all is said and done, this is the way it's got to go. So I appreciate your coming out. I would like to just give my affirmation that I believe you're heading in the right direction, and I appreciate the effort.
Well, when this board voted 3-2 to defend this lawsuit, this litigation resulted. And there's a cost, a greater cost than the insurance company deductible of $7,500. And it is in terms of disruption at the park. It's in terms of a 30 or so document request from an attorney under a general law. There are depositions scheduled that are disruptive to schedules so that there is a cost. But this board voted to do that. And what I'm saying is that we don't, other than deciding whether to prosecute, defend, or compromise, this board can't engage in telling an attorney how to litigate a case. I don't think.
That's
You're
my
saying
question.
that in your, I apologize for bringing this in, but that in your practice, you never go to a client and say, well, we're at a choice point, and I'd like some direction as to which direction I should go in?
That absolutely should happen. And I heard the opinion of Sam Perkins as to how to address the issues that Attorney Valenzola raises. He plans to file a motion and have some clarification on that.
And we thanked him for his information. I affirm that that's a direction that I would like to see him going.
And other than that, I don't know what else there is to say.
Well, do you guys want to talk first?
No,
I got another question.
I think, I agree, actually, with Bob and Jim on this, that look, I mean, this is the way it has to happen. I don't think this board needs to take any additional votes to allow Sam to go forward. You know, what was tested by people in town, or what was tested at the dog park, was the exact order that Judge Long issued. So I think it's absolutely under Attorney Perkins' purview to go back for clarification on the order. I mean, that's what was tested. It's not something that's, external. It's that exact order. So if he goes back for clarification on that, I don't think, it requires any additional action from this board.
What about, what's the word, a summary motion?
Summary judgment.
I can't say, I'm so cotton-mouthed right now, but thank you. Does the board need to vote to have you do that?
I certainly would want the board to let me know if they thought that was an inappropriate way to go. I do think that's something of a no-brainer. That the quickest way to resolve the case that's known to the law is summary judgment, and I think that I would expect that as my clients, you would not want me to delay in trying to resolve the case. There is no guarantee that it can be resolved quickly.
If I may, are we not all of the opinion that the question as to whether or not a passive recreational use includes a dog park is one that is not settled by the courts?
I'd agree with that.
And isn't that, didn't we also have a talk about that's a question of factual determination that the court will make?
I think that probably is true.
And isn't it also a matter of summary judgment law that when you have a factual dispute that has to be settled by a trier, that's not an appropriate motion for decision at this particular time? Am I incorrect?
No, that would be correct if, in fact, that's the proper characterization of what we intend to present to the judge. But, Jim, as I imagine you can guess at this point, I have a slightly different characterization.
Well, I guess those are the things that we're not getting, Sam. We're not getting your characterization. We're not getting your understanding of where the
That's why I'm
case...
here.
And I'm glad you came, though I didn't know you were coming tonight to discuss your characterization of the particular case and where it's going and what your intent is. So,
Happy to answer any questions.
well, rather than answer the questions, I'm happy to hear what you have in mind.
On the summary judgment issue, if it's possible to end the case quickly, I would like to try. My proposal is that we propose to Judge Long that if, in fact, the rules and regulations that he has imposed and that the dog park has adopted are followed, that as a matter of law, he would find that a dog park operated in that fashion was passive enough recreation in order to qualify as an appropriate use under the conservation statutes, or any other legal standard that he finds applicable. In other words, rather than him having to make findings of fact about how the dog park is operating today, next week, next year, or 15 years from now, he would say that a dog park set up with these characteristics is appropriate for use on conservation land. That was how we would try to present the issue to him. There's no guarantee that he would agree to decide the case framed that way. There's no guarantee that he would proceed without allowing discovery by both sides on issues of what actually has happened up till now. But it's my judgment that that is something that is worth trying in order to resolve the litigation quickly.
Didn't the original court order contemplate the Foxboro Police Department becoming involved at the dog park?
There's no question that the judge talked about the issue of whether or not monitors who were not law enforcement officers would be successful.
What can you just enlighten the board and the town as to what the judge meant by that and why? Whether or not you think that the response of the Foxboro Police Department was appropriate, is it to be expected in light of the ruling that the judge has made?
Mr. Chairman, I'm happy to give you my opinions, but I'm not sure that my opinions are worth any more on issues like the ones you've asked about than any other informed citizen who might be interested in the dog park and those issues.
Well, we disagree on that because we're asking for your advice as the attorney, and you've just opined on the matter of summary judgment. We raised an issue relative to a police report,
Yeah.
and Mark wanted you to address that.
If I could make
Excuse me, Bob, just let me finish. Did the judge's order contemplate the intervention of the Foxborough Police Department at the
It actually
park?
requires it. It
Requires
requires it under
okay.
certain circumstances.
All right, thank you. Bob?
I do not believe Mark's question was did the police department act appropriately. I believe Mark's question was relative to the people who were causing the incident in the first place and how, and perhaps Mark could clarify better, but I'm not really interested in whether the police department has an opinion of our council. Quite frankly, I think our police department acted very appropriately. Sergeant Miller and then Patrolman Miller and then Sergeant Thibodeau went down and they handled the situation well and de-escalated the situation, moved the people who were not following the rules out of the park, and that's what the police department should have done. So I give them praise for that. I think the question is more to the point, is it appropriate, and Mark, you can correct me if I'm wrong, but is it appropriate, in your opinion, that the attorney become an active participant in an action where he's now going to be part of the incident as opposed to an observer or someone who is defending a position where he's now actually going to have to defend himself and his actions? And I think that's the question that I had going into tonight, and I'm grateful that Selectman Sullivan invited you to the meeting because I think it's appropriate that you be here at this juncture.
I think on the issue of Mr. Valenzola himself being the person who was in charge, apparently, of the decision to test the rules is extremely unusual. It's the kind of thing which you virtually never see lawyers doing for a fairly simple reason, which is that once the lawyer becomes a participant and a necessary witness, as I said in the memo I sent, ethical rules for lawyers in Massachusetts and virtually everywhere require that he step aside as counsel for the parties to the case. Given what he argues in his letter today, he also could be a plaintiff. He claims that the civil rights of his clients were violated by the actions of the monitors and the police. He obviously was exercising exactly the same rights. So by becoming a participant, lawyers put themselves at risk of being disqualified.
Now, have we put forward any opportunity to compromise what has become a seemingly intractable, is that the right word? Problem. Have we attempted to compromise it?
Not since well before the most recent hearing.
Oh, actually, I contacted two of the abutters to see if they want to sit down and talk. One said his phone he would always be available, and the others never replied. And then a couple others in a public function told me, don't bother. So I let it go again.
I think that this board, it's an excellent point to make, but I think we also need to make that the Conservation Commission and our board held many discussions, and Mark Sullivan in particular has done yeoman's work as far as attempting to compromise and create solutions. It was the plaintiffs that chose to go down this path, and as they've gone down this road, we now have a responsibility to the town to defend the position by 3-2 vote, as you point out. And we put it in the hands of our attorney to respond in kind to their attorney's actions and filings and letters and whatnot. So I think that the compromise, while it's an easy word to say, is a little bit of a red herring in that the attempts to compromise were not met favorably before, and now it's at the point where if we were to compromise, and Mark, it's interesting, you said that you had those communications, if something were to come of that, it could be used by the plaintiff as another leg to stand on for their suit, and that's why I'm not comfortable having the communications outside of our attorney, and I'm glad that you're here to, again, review this with us.
Right. One of the things I did want to raise with you, though, early on you said that you would share all the paperwork that you had with everybody, but I haven't seen it. Would you be expecting multiple packages to come in, Sam, or how do you intend to communicate with us on a regular basis?
I'm Jim, I'm not sure what you're referring to. I think that everything that I filed, every communication that I have, I think the only exception to the sharing with everybody was the communications you and I had with each other last week, which then I eventually, at the end of five interchanges,
Those were the emails.
sent to others.
We had a couple of things that we were talking about at the meeting. You raised the issue of ownership, and I was hoping to get some clarification of that, because it seemed to me to be an important issue that, as I recall, you said that the Conservation Commission owned the land. But that really is not relevant anyway, is it?
Well, I think the issue of who owns the land and who controls the land are both relevant, and as I think I tried to make clear in our interchange, the land is owned by the town of Foxboro.
Well, then
It is the record owner.
Okay, that's where we...
Conservation laws and under the terms of the deed and under town council's opinion, and as a personal matter, I agree with town council, the conservation gift and the conservation statute give management control of the uses of the land to the Conservation Commission.
But on the sole issue of ownership, which I understood from the February 18th meeting to have particular meaning to you, it was the control issue that has the meaning rather than the ownership issue.
I think the control issue is an important issue in town and had a good deal to do with the marching orders I was given as litigation counsel. I know from conversations with you on multiple occasions, the question of what board or body in town controls the uses of the land has been the subject of some discussion within the Board of Selectmen and others. When I entered the case, the selectmen had made a decision to defend the lawsuit, and the posture of the lawsuit was that a decision had been made by the Conservation Commission about the appropriate use of the land. So I am defending the position of town council and the position of the Conservation Commission as the appropriate body to make that decision, and having made an appropriate decision.
And the other issue that you and I were discussing was, and I'm still waiting, I keep saying it, but I keep waiting for our lawyers to say it, that the question remains unanswered, and that answers in the form of case law come through appellate decisions. So can we not ultimately expect to see this thing through? The town of Foxboro is the town that will litigate the issue of whether or not a dog park is a passive recreational use in Massachusetts.
That certainly is one way the issue may be framed and decided. There are alternatives, but that's the most likely one.
So what we can expect is that regardless of the outcome of a summary judgment motion or a trial, that the case conceivably could be appealed and then appealed again for an ultimate decision by the Supreme Judicial Court as to whether or not a dog park is passive recreation.
Well, I think that statement is true of virtually any litigation. If you want to spin out the scenarios that will keep this litigation going on a long time, you may see other groups and organizations entering as amicus, saying they want to take a position on dog parks.
We almost agreed, but what we first agreed on, that there is no law, case law, establishing a dog park as a passive recreational use.
Absolutely, no decision on that at all.
And there are sometimes cases make rules, and those rules are followed, and the fact patterns fit within the rules, and we know how it's going to come out. But when there's no rule, the rule, unless it's made by the legislature, comes through the appellate process at the SJC.
Absolutely.
Okay, so just in terms of what we can expect as a town, this is something that could go on and on, up an appellate ladder over a course of 3-4 years?
That certainly can be true of any appeal. Yeah.
And there's nothing that would prevent us from drafting a compromise plan that we could take to the plaintiffs and say, look, we want to settle this case, compromise this case by, for example, moving the park away from the direct abutters, maybe over to the side, maybe reconfiguring the fence, maybe limiting the hours so that it's not constantly expanding with more monitors from 7 in the morning until 8 at night. And we could present this and say, not only to the abutters, but to the town of Foxboro, that we as a group of people made a reasonable compromise to prevent what could be a very long, protracted series of decisions and briefs, etc.
I think, Mr. Chairman, it's a truism that resolving disputes by agreement and compromise is usually preferable to litigating them out to the nth degree.
But there's no reason why we have to wait for the 17 plaintiffs to say we'll settle. We could, as a group,
I think we've established that we can do that.
decide that, look, we're going to suggest that we move the park to this side, and we limit the hours here, and we're going to have no more than 20 dogs or 30 dogs. We could do that, right?
Everything is possible in compromise.
And probably all of this would stop if we did that.
Well, I don't know.
I'll reinstate that I tried to make.
Well, maybe we should make a comprehensive
Mr.
effort
Chairman,
next
if we're going to be
month.
having this discussion in open session for the benefit of opposing counsel, I'd recommend that we go into executive session.
I'm not going to go into executive session. I'm suggesting that compromise can come from both sides, and we could do that if we wanted, Sam, right?
I thought we
I-
tried that.
I think
my marching
we're
orders
well.
from you and from
Didn't
the
we try that?
Conservation Commission.
We've not. We've
When
never
they
put
came in,
forward.
Jim, didn't they come in and we
No.
sat with them?
What we have never done as a board, and is our promise under the Town Manager Act, is to offer a compromise of this litigation, a comprehensive compromise about how perhaps we could structure this park in this location, in this configuration, as a means to end this whole lawsuit.
And I did, Jim. And I tried to reach out to them, and they told me to talk to legal, not to talk to them unless they went to
But-
legal counsel. Hold on, hear me out. So now I'm being deposed.
Part of the problem, Mark, is that none of us have any authority. We can only do things here. We do not, you can't speak for us, you can make all the statements you want, but you're doing it on your own time. The only thing that matters...
As you are too.
Yeah, absolutely. And the only thing that matters is a vote of this board, and I'm thinking that perhaps in May, we get together as a board and we say, look, here is our reasonable compromise proposal. And I'm going to, under the Town Manager Act, it's this board that has authority to compromise that litigation. And I would hope that if a compromise was reached, that we would have the support of the Conservation Commission, because I can't imagine this is a lot of fun for your group either. Bob?
I will say, you may not have compromised, but the Conservation Commission certainly has compromised. We're going to put up a buffer, a 5-foot berm planted with trees along the inside of the fence. The gate is to the water area is going to be relocated to the other side of the facility shed there to keep activity away from the abutters, and they don't want to listen to it. I mean,
You can still do those things on your own,
We
maybe.
will do
because-
those,
Have you
but-
given any thought, was there really 80 dogs down there the other day? What-
not when I was there.
No?
I don't know.
I mean, that sounds like a lot of dogs.
That was
Bob.
during
You gotta-
the whole day.
You gotta admit that that's a
That
lot
can't
of
be-
dogs.
James, that was the whole day. At 10 hours, 80 dogs showed up, not 80 at one time.
There were maybe 15 when I was down there, and they were. I will say they were very excited. They were very happy to be back there. But nevertheless, we made the proposals. Attorney Valenzola came in with his court stenographer, by the way, to take every word said. 61 pages, which we're going to pay for, of testimony.
Why are you
Just-
gonna pay for it?
Hmm?
Why are you gonna pay
The
for it?
Conservation Commission, out of their budget, will pay the $61.
You didn't hire the stenographer.
To get a copy.
We would like.
Well, then, okay, then he's doing a good thing for both sides. You don't have to buy
a
it.
good thing.
Wait a minute, you don't have to buy a copy if you don't want.
He came to their meeting and
He
it totally.
came to our meeting and
Listen.
took down every word, trying to see, quite frankly, if he could get us in a contradiction.
Sam, is that legal?
It's an open meeting. He can do what he wants, I assume.
Is that legal for him to bring in a
It's
stenographer?
Absolutely legal.
I don't know.
Is it, we don't think it's illegal, do
I
we?
certainly don't think it's illegal. I don't
Well,
know.
Pauline, are you getting all this down?
Every word.
So you decided to buy a copy of this transcript.
Just so that
Okay.
we can see what,
Fair enough.
he's got.
My question, and this is all pertaining back to this whole situation here, is if they're going to pursue on doing this and try and disrupt the situation down there to exhaust the municipalities, which I was worried about in the beginning, which they're doing, how do we stop it? That is my question here.
Summary judgment.
Supplementary judgment, summary judgment, and I also want, if I have to, and anybody can do this, and I'm going to ask Sam the question, How would a judge see upon this if it happens even another time when it came to a disinvited restraining order from the persons involved in either situation? How would he feel about it?
Well, let's keep a couple of things in mind. Right now, the litigation we have going on is in the land court, and Judge Long has shown an interest in making sure that he regulates what goes on there. The letter that Mr. Valenzola sent this morning talks about raising litigation in a whole new context, in the Superior Court or even in the federal court. And questions about whether or not behavior that's happening down there, either by the town or town officials or the operators of the dog park, or by the plaintiffs, could come up in the context of a federal court case or in a Superior Court case. Anyone can file a motion for a temporary restraining order or a preliminary injunction, as the plaintiffs did in the land court case, to try to keep people in line, obeying the rules down at the dog park. So, to use your example, if in fact there are repeated incidents down at the dog park where the rules are being tested one way or another, it's always open to the town to authorize its council to seek an injunction to prevent those kinds of behaviors from recurring.
My major concern here, and it's going to happen, is there's going to be some kind of fight or severe argument where somebody's going to get hurt. That is my situation. I mean, I don't want to see that happen. So, I'm asking you, I just got your answer. So your situation right now is you're going to, and I thought we had to vote on this. That's why he's here. Summary judgment, and you're going to do what about Valenzola's actions?
What I'm hoping to do, rather than raise this as the question of the judge ordering somebody to do something or not do something, is to ask the judge to clarify his order. And what I'm hoping along the way is that he will encourage the parties, rather than engaging in acts of civil disobedience and confrontation with the police and the operators and the monitors at the dog park, if they have a question about the rules, file a motion with the judge, ask the judge to answer the question, and that way we don't have to have the cops called down to the dog park.
But the problem with that is I think we're treating them differently, though, than if average citizen wanted to go down there and had a question on the rules. We wouldn't tell them to file a question with the judge. I mean, they would go down and do the exact same thing. They'd go down, they'd be told to leave. Whether or not they decide to leave is up to them, and if the cops are called, then they have to deal with that. But, I don't want to get into a situation.
All they were asked to do, though, Paul, is to sign in, just like everybody else.
I'm not debating how,
But that's how your average person would go in there, too. The average person would go in there and sign in.
What I want to avoid, Attorney Perkins, is singling a certain individual out or a certain group out and saying that we would expect them to act differently than we would expect any other citizen in town or outside of town.
And I agree with you completely. I think that what does set potentially this group apart is that there may be repeated actions. Once somebody shows a tendency to go back and do the same thing over and over again and provoke incidents that require the police to be called, then you do have to take a hard look, as Mr. Sullivan has suggested, at whether that behavior is part of a pattern that the court perhaps should start intervening in. You're not singling them out and treating them differently. You're treating them specifically because they're behaving that way.
That leads me to another point. Didn't the judge himself say that he expected the plaintiffs to monitor the dog park?
Monitor?
Didn't he
I
tell?
think everybody expects people to keep an eye on the situation. Civil disobedience is not the same as monitoring.
No, but didn't he say that specifically? He expected that the plaintiffs were going to be watching how it was being run.
Yeah.
Okay.
But that's different than breaking the rules.
We don't know if they broke the rules yet.
Oh, we do.
We're
too.
gonna-
It's stated in the police
broke the
report.
rules.
Your reading of the order.
No, the rules,
The
Mr.
rules.
Chairman, consist
Oh,
of
the
what
rules.
the Conservation Commission has imposed as rules.
Are those
Done
different
with-
than the judge's order?
Some are in addition to the judge's order.
Did the judge's order contemplate the adoption of more rules?
The judge said nothing specific about whether only his rules would be applied or whether the Conservation Commission might actually do some of its own thinking and impose additional rules.
But the conservation rules could not run afoul of the order.
No question about that.
Could the plaintiffs file a motion for a clarification as to whether the Conservation Commission has the authority to issue the rules?
I wish they had instead of showing up last Thursday.
Okay, so we've got,
But a little more civilized.
we're not making too much progress if both sides can say, well, you couldn't adopt this rule and the judge's order said this and that. Why don't you go get it clarified for us Attorney Perkins, and
Thank you,
then we'll
Mr.
take it
Chairman.
all up. Is that, we need to take a vote on that? Bob, you're making a smirk. Go ahead.
I'm not making a smirk. I'm debating whether to go, but I'm certainly not making a smirk.
Okay.
I take this very seriously. There's 18 citizens in this town.
I take it seriously, believe me.
Thank you for letting me finish. That are suing this board, and then there is an overwhelming number of volunteers on the Conservation Commission, the dog park proponents and volunteers on this board who are being put in positions where we're having to defend against, quite frankly, some people who are not playing by the rules. If it's a disagreement, there's certainly avenues they could have gone through with Conservation, even with this board. They came to many meetings. One of them pushed a lady that was in the audience here as they were going out the door. So to Mark's point, I do have a very unhappy feeling that it might escalate, and that's why our police department may well have to go out there again, because they've proven in the past that there are incidents that could occur. So I take this very seriously, and I'm just questioning whether this board is fully aware that we took a 3-2 vote in favor of defending this position, and why we're having this type of discussion for the benefit of the opposing counsel, perhaps.
Well, is this executive session stuff that we're talking about here, Sam?
I think it's up to the Board of Selectmen to decide whether they need an executive session or not. There's certainly nothing in what we've discussed up till now, which is your attorney, I think, would need an executive session.
Thank you.
Discuss this in front of the public.
But when talking about strategy, that is something that we would go into executive session for. Am I not incorrect in that?
When it comes to this particular litigation and this particular lawsuit, if we're gonna do an executive session, I would like whatever member wants an executive session to reduce that issue to writing. We'll submit it to council. Council can give us his opinion as to
Mr.
whether or not
Thrasher, you
that's
don't
a
have the
matter-
power to overrule the open meeting laws. I will not do that for you.
What?
I do not have to submit in writing to town council if I wish to go into executive session.
To get an opinion from the attorney who's advising us?
I do not need to go to my attorney in writing prior to asking this board to go into executive session.
All right.
Do we not agree?
There's nothing.
We're going to agree that it takes a vote, and if an issue comes up and you think it requires an executive session, I'm going to ask that I'm not going to vote for it until such time as I get an opinion for council that that particular issue is ripe for executive session discussion. I'm not going to
So-
violate the rule again.
So as,
I'm not going to vote for it, Bob, until,
I haven't even made a motion. How do you know whether you vote for it or not?
I thought you wanted to go into executive session
I
on
say
what we
I
Okay,
was-
discussed.
can we move along, please?
Yes.
I'd
I'm
rather
happy
keep
to
going
move
and
along.
tell you the
No,
truth.
no, I want to move along.
I think the final thing that I'd like to know is there anything else that you need, Attorney Perkins, to assist with your defense?
I think I'm all set for now. I would request that if the board does want to go into executive session, and I'm happy to give my opinion about whether it's appropriate or not, it would make more sense to do it in a properly noticed meeting where the possibility of executive session is announced so that everybody knows well in advance.
Just as we've done with this meeting, in which case we have an opportunity to go into executive session to review the possible release of executive session minutes from a previous meeting.
And I have one more question for councilors. Why has the vice chairman been deposed by Attorney Valenzola and certain two others, not everybody?
Don't know. Can't imagine.
Can we ask him that question before we concur that we would meet?
You mean, can we require him to answer before we
Yeah.
actually show up?
Yeah.
Nope, that's not how discovery works.
Does he have a right to depose any defendant?
I think that he has the right to depose until things become abusive and the court orders him not to. He can depose anyone in the East Coast.
So we could expect that there would be more depositions.
I don't know what to expect.
But, I mean, there's no reason not to expect it. That maybe simply establishing an order of how he intends to take depositions.
No, if you go by file rank and command, you go from the top down or the bottom up. You wouldn't start with me.
Well, we can only speculate about how far this will go.
Well, it's his defense, and we can't certainly
Unless, of
presume
course,
how he wants to run his defense.
Unless, of course, it were compromised and a plan was put forward that was palatable to everybody. Maybe everybody's tired of it.
Well, then why don't,
We're not going to do it tonight. I'm just throwing out ideas. We talked about the sewer for an hour. Talked about funding that.
Yeah.
I appreciate your coming in.
so Attorney Perkins, I have a few more questions. Attorney Perkins, is there, with regard to the last few letters, and maybe Andy and Attorney Perkins can answer this, What additional information have we yet to provide to opposing counsel that will satisfy his request for information?
Well, we're at our office, everything we have or received during the past several months, we're copying. I've had Attorney Perkins review it, and we're going to release it to him tomorrow.
Okay.
I'm not holding back anything.
Well, I know we're not. It seems like the list keeps growing and growing.
Well,
so-
whatever we have, we're releasing them.
Okay, so that'll be going out
And we don't
tomorrow.
have everything that he's
Conservation
asking for.
Commission.
Well, I know he's also asking for some things that don't exist. Is there a way to formally tell him or to tell the judge and him that whatever it is he's looking for just simply does not exist?
We can mark his letter. We can do his letter up and. No, the
I just don't
the
keep
items we-
seeing the same thing over again.
the
I know
items
the
we have,
town
we're
staff-
releasing.
I know the town hall staff are getting stressed about this, and it's not fair to them to keep.
Just as an update,
Regurgitating
Conservation
this.
Commission, I have a draft from the Conservation Commission Secretary of the response. That should be completed by tomorrow, and those documents, or an estimate for the cost of doing the research that's been requested, will be sent out. I would note that both for the Conservation Commission and the Board of Selectmen, Ed Valenzola's letter of this morning has thrown in with 12 pages of constitutional claims and other complaints, additional public records
Yes.
requests. And I think that, given what's happened up till now, we would do well to pay close attention to those as if they were formal public records requests that he'd made in a separate letter.
Okay.
I think that's a fine idea. It just, not to belabor a point, but we can expect more, what other types of discovery should we anticipate?
I can't speculate, but we all
I guess
know
I'm
what
asking you to be the
possibilities.
lawyer. You can file interrogatories,
Yep.
right? And there's written questions that we have to answer under oath. Designated agent has to do that. We're not compensated for that, correct?
Yeah, typically, as
Okay,
as you
so
know,
there's
as a
time and
litigant,
effort
the
that
crash,
somebody's
those
gonna-
those answers usually are prepared by counsel in consultation with the client.
Right. They can make formal court filing requests for production of documents that's different than the statutory filing, but we would assume that if it's covered by the statutory filing, we're going to have it available for a court filing.
No question.
You could depose any one of the 12 defendants and any other interested person or witness,
Yes.
and those depositions require the appearance of the deponent at a law office for a period of time
For almost no compensation.
for no compensation. They too can file requests for admissions, which can be long and tedious and time consuming to deal with, correct? So that there are a number of things that can continue to impact on the various defendants in town hall.
Just having to talk to me can be burdensome for all.
If there,
I like your sense of humor.
if a person no longer belongs to the Board of Selectmen,
You're not resigning,
as
are you?
things change all the time, do you still have to be involved with this case?
If you're asking whether, for example, Mr. Hawking's deposition could be taken, of course, it's going to be.
That's exactly what I'm asking, because there's two people from Conservation that are going to be leaving in May. Are they still in, no matter what, they're still involved?
Sure, if you're a witness, your deposition can be taken.
So it sounds like the old divide and conquer and wear them out is going to keep going and going and going, ain't it?
That's the nature of this.
Well, I learned to
business,
walk
right?
both sides of the street. We'll see what my side has to say.
I just have one more question, Mr. Chairman. I suppose in the spirit of the open meeting law document search, are we certain that we have everything that we have? Has anybody in this board had any communication with opposing counsel, Valenzola, that we need to disclose, or are we all set with that too?
Have you?
I have not, have you?
I haven't.
Okay.
Neither have I.
And why would that be something that someone would have to disclose? Are we prevented from communicating with Attorney Valenzola if we choose to?
No, I think you're all elected officials.
So, if we were
Without
to have,
going through you, I would never. I'm
But
saying,
you're not-
would that be your advice for me to contact them directly instead of going through my counsel?
I wouldn't advise it, because there's 5 of you, and that can
Would
produce
you-
some mixed messages, but.
Would you find it helpful?
I think as long as it didn't go too far down the road before you included others in the communication.
but it's not illegal.
No, of course not.
And is it a requirement that if someone has a conversation with an abutter or a plaintiff or an attorney from the other side, that it be disclosed to all the defendants?
Well, interestingly enough, the only real limitation in that scenario is on Ed Valenzola himself, because as a lawyer, he's not allowed to talk to people who are represented by another lawyer, namely me, without letting me know and getting my sign off. I'd be happy to give it for any selectman who wants to talk to Mr. Valenzola about this case.
Okay,
And
so
I-
we're all clear on that, right?
Yeah, we're all clear, it's not a good idea. The other thing is that, as you know, Valenzola has gone to conservation and spent an hour and a half trying to stir things up and cause an uncomfortable situation. Can we, and I'm saying, ask you, that if he's going to show up at any town meetings, be advised that we're not going to talk to him or acknowledge him unless our counsel is present, being that we're involved with the lawsuit?
Mr. Sullivan, much as I hate to disagree with you,
I'm asking.
as much as I respect the effort you put in on behalf of the town, I think there's one thing that's clear about this type of litigation, which is that the more town officials are pressured by public records requests, by litigation, by people coming to meetings and being perhaps pushy about asserting their rights, the greater the chance is that a town or town officials will retaliate in a way which, as Mr. Feeney was suggesting, is problematic, singles out people because they've exercised their rights perhaps aggressively, but still appropriately. They get singled out because they're being aggressive about exercising their rights, and the town's retaliation in singling them out then becomes the basis for a new claim. I would caution everybody who represents the town not to rise to that kind of provocation.
Well, I'm talking about the Board of Selectmen. If he comes here, we're in a lawsuit against him.
The fact that he's in a lawsuit against you does not change your obligations to him at open meetings, at allowing him to participate, or...
No, I'm not saying that, but if he's going to ask direct questions to me, as a member of the board, during a meeting, or any other member of this Board of Conservation, why on earth would we answer any question from him without you being present? Or asking the question through you?
There are absolutely appropriate limits on what Mr. Valenzola or anyone else can ask during a public meeting of a selectman. He can't ask you personal questions that invade your privacy. And if he asks questions that, for example, invade the question of litigation strategy or your communications with me, those are inappropriate questions which you can decline to answer. The problem is that if Mr. Valenzola is asking a series of questions, some of which step over the line, some of which are close to the line, some of which don't, the chances of a selectman responding inappropriately get higher and higher and higher. That's why patience becomes the premium.
Well, that's why I'm asking the question, how am I supposed to know the difference between A, B, and C?
Maybe you have to have counsel at your side.
Well, that's what I'm asking. Why should he be able to ask me or any other board member a question without having you by my side?
I think that's part of what you signed up for as an elected official.
Yeah, you can't tell him not to simply because he's defending.
I'm just trying to ask Paul because I don't want to make a mistake.
I know, but and I don't want you to make the mistake, which is why I don't want you to be hit with a slap lawsuit, which is, you know, where you're treating him differently because he's a defense attorney.
He's treating me differently.
But Mark, he's not. We're not just defendants in this case. We're elected officials, and I think we need to be clear that as much as we want to cowboy up and dig our heels in and say, well, we're going to fight, you got to look at principles over personality sometimes and say, you know, I have to understand as an elected official, I take on a different persona than just, you know, a defendant in this case, and just a private citizen. And it's hard to do, but it's something that we need to be mindful of.
And sometimes people make statements about you and your family, and you can't control that.
Ain't that the truth? Well, you know what? If there's anybody out there in the whole United States that wants to see the case precedent set by the town of Foxboro, we'll take your donations. So send in your emails later.
Any other questions? Mrs. Harding?
I just have one question for the board in general. I was just wondering if any of you kind of feel the way I do from listening to this, that maybe Attorney Valenzola's strategy at this point is that maybe he sees his case as weak, so he figures if he just inundates the town with motions and requests and tries to take up everybody's time, that maybe he'll do exactly what you're leaning towards, which is trying to get people to say, forget it, it's not worth our time, let's just walk away from it. And I would hate to see him succeed in forcing the board to do something like that. I just kind of wonder what your feelings are.
Mark?
You're the lawyer.
She's asking the board, I pass it to you.
All right. Well, you know what, Heather? It's already happening as far as I can see, so, you know, we'll just see how it goes down the road. And I wonder if in this new election coming up, that if the board does change hands and Mr. Hickey does lose, that is it be able to be... No, I'm serious. Well, we voted 3-2 to defend the case. Does the board then, if it convenes and you're no longer part of the game and the next person that joins the board decides not to defend the case, do we stop there? That's my next question.
Well, I think that a future board can certainly make a future vote that might be different.
So-
I think that's something that people in this community need to be aware of.
Well, hey, you know what, so things can change in 2 weeks.
Bob, you want to address Mrs. Harding?
Yes, I'd love to address Mrs. Harding. I apologize on behalf of the board and on the Conservation Commission, I'm sure, for the trouble that you had to go through last Thursday in dealing with an unpleasant situation, and I'm glad that it resolved itself without any further escalation.
Linda?
I guess, and for a penny and for a pound, I guess, at this point. I mean, you know, yeah, it was, guess what, folks, in case you haven't heard, it was 3-2. I was one of the 3 that agreed that we need to fight this, only because, you know, I don't want to start, you know, opening the door to folks, you know, undermining the judgment of other boards in town. And I'm going to stick by the Conservation Commission. I witnessed compromises between all you guys. I remember Bob telling us that, you know, they came in, they mentioned this, we've done this, that, and the other thing, went above and beyond. So there was compromise. Maybe it wasn't this board, but maybe it was the Concom, and I'm here to support you guys. And I am, it's unfortunate that we couldn't, compromise didn't work in this instance. But now we have gone this far, and we have to go. We have to continue it. We can't back down. So that's my feeling.
Paul?
I think the question, you know, could this be his strategy? Yeah, certainly. I think he can employ a myriad of strategies for his defense. You know, do I think it is or not? I don't know. I don't think it matters. You know, he's going to defend the case the way he wants to defend the case, and the defendants direct him to. As far as, you know, and Linda brought it up, voting to defend the case or not, again, just from this corner of the table, speaking for myself, the vote that I make whether or not to defend the case isn't, you know, as hard as it is sometimes to say, you know, I want to stem the tide, and I want to stop any future litigation. You know, you got to look at each issue that comes before us at this table without prejudice and based on the merits of what is in front of you. And that's what I did, not based on the fact that I'm nervous that other people will come and, you know, sue the town because of decisions that other boards make. I was pretty clear in what I felt about the merits of the case after, you know, sitting through many of these meetings, and I made a decision that I thought was appropriate based on this case. No future case, no past case, and that's it. With that being said, the board voted that night to defend 3-2. We act as a board. You know, we have defense attorney now. I think he's been clear of what he's going to do going forward. So I think we move on.
Okay. Anybody else? Lorraine, you always sit so patiently.
I just have a question about water and sewer, so
Forget about it.
My only other question would be to Attorney Perkins. We gave you what we believe, what Paul and I believe are answers to the ADA's letter. So I'd like to hear your
Great job.
your comments on it.
You did a
They
good
did a very nice job. Can you stay so that we can finalize this? Are you going to be the responder to the district attorney?
I think that the Board of Selectmen, as I heard the
We're
last
going to
meeting-
respond directly, so it doesn't.
Yeah, the cover letter signed
Okay,
by
so
Paul and
we
I.
don't need
I think-
anything.
Now, Attorney Perkins, I saw it, was it a draft that you had responded to the ADA? Did that ever get sent to the ADA, or is that?
No,
No, at our last meeting, when I was last before the Board of Selectmen, that issue was discussed but unresolved.
I mean, I think our response, you know, comes from this board. If Attorney Perkins wants to
No,
respond.
you're right, you're right.
Assistant District Attorney, I think he has the right.
I agree with that. Anybody disagree with that?
Do I take that to mean that the letter that I drafted last time I can send on behalf of my clients?
Sounds right to me.
But, wait a minute, now I threw something new in there.
He disagreed with the attorney's findings and said that we would comply.
You wrote a letter, and you want us to approve the letter?
I think that's what Mr. Feeney just read.
I wouldn't think that we would approve it. I think I would support the fact that you have the right to, as as, you know, our attorney, and somebody that was named in that ruling, to respond as you see fit. I
Yeah.
don't think you need approval from this board.
I don't see it as part of our record, what you have to say. We've tried to clarify, the subcommittee and the persons who participated tried to clarify the errors that were identified, the factual errors that were identified. If you want to write something else, fine. If it's in front of us and we need to read it, vote on it.
I think you saw it several weeks ago.
Yeah, we did.
Forgive me, but I can't recall it now as to be able to vote on it, include it if it's not here in the package.
Do you think, though, Sam, that you would need our vote to respond to the assistant district attorney?
I think the way we handled it tonight, and I'll certainly take this direction, is that if the board says that I can go ahead without taking the formal vote, I'll go ahead.
I mean, I would support that. You know, regardless of what's in it, I think if Attorney Perkins wants to respond to the assistant attorney, you know, he has every right to.
Yeah.
I think that would be consistent with the discussion we had about half an hour ago. Absolutely.
Yeah, I think that that's appropriate too. If I were in your position, I probably would want to file my own response, regardless, to clarify certain things that were on the record that may have been inaccurate from your point of view, if that's what you intend. Is that what you intend?
My intention is to clarify the record. Obviously, I don't have a dog in his hunt, except perhaps a certain amount of personal feeling about his response, but I'll do this on behalf of my clients in this litigation.
We did say as a board, and all board members can correct me if I'm wrong, that we did not intend to fight the district attorney's finding that there was a violation.
Well, I think the timing of this, and certainly the tone of the subcommittee's letter, make that crystal clear.
Okay. Bob?
Okay. Just want to make a comment that within the open meeting violation, assumed or actual, since we followed Attorney Perkins' recommendations that morning, both at the park and here, I think it would behoove Attorney Perkins to explain his thoughts, not our thoughts, but his thoughts to the ADA as to why we did not violate the open meeting law. So I think it would be very appropriate for Attorney Perkins to send his letter stating his position, and also have the Board of Selectmen send in the letter that has been proposed tonight, which I think is an excellent job, pointing out all of the inaccuracies that the ADA had in his ruling, so that both the board and our attorney have their own say. So I think it'd be very appropriate for Mr. Perkins to send his letter in.
Thank you for your opinion. Anybody else? I'd like to make a motion that we,
I think Lorraine had a question about water and sewer.
Oh, no, I'm waiting until you're done.
well, we're going to go into executive session, Lorraine, so go ahead. Thank you, guys.
Article 21, I'm sorry if I missed it, I stepped out for a second. Is that being withdrawn?
No,
So it's not being...
nothing's been withdrawn.
22 is the funding article.
21.
No, it's going forward.
She's talking about 21, right?
No, 22.
22.
Funding. Just wanted to let you know that we are hoping for the 30th, and we need that, you know, Randy just received a lot of financial information. He's crunching the numbers that we would get the financial information, and we've asked for more information about the betterment and how it's calculated. The question about the equalized users, just, you know, from a general concept we've been discussing, you know, if there are 2,500 households that are going to be the beneficiary of the sewer system, and 800 of them are individual homeowners, how does that translate into the calculation of this betterment? So that's really something that we're looking at right now too.
Yeah, he gave us an explanation, but I'm sure that he'll give a similar explanation before your board.
When are you guys meeting on that?
30th.
30th.
See, we got that explanation.
You did get
We got
that,
that
yeah.
explanation, but that's what we're further investigating.
Yeah.
And then we have another meeting next Tuesday as well,
Well,
as there's 5 Tuesdays in the month of April.
Yes, we do. You never
we
know.
do.
Yes. And this is,
Are we, Mr. Chairman?
not,
in a row. Motion to go into executive session?
I don't know who we talked to about that.
We're gonna do that right now.
Thanks
Motion to
for
go into
Jim,
executive
hang
session?
on.
Come on.
Jim.
We all done?
He wouldn't let me make the motion.
Are you leaving?
Yeah, no, we don't need you, Sam.
Well, it's,
What
Yeah.
are you going to do?
Let's adjourn first. Yeah.
Well, I guess,
I'm happy to stay for
Well,
the
we're-
executive session if you think I can be.
We're talking about the executive minutes
Minutes,
from
yeah.
that.
I would certainly want him to stay for that.
12? Minutes to
well, I guess you're not going home yet.
Just let me no, I'm not leaving. Excuse me, I'll be right back.
Hopefully it'll be 1 minute.
Now, what motion do we want to make now?
Well, at the risk of making a motion without submitting it to attorney in writing, I make a motion that we enter into executive session for the sole purpose of reviewing the possible release of the Selectmen's executive session minutes of February 12th, 2008. We also are going to review continued collective bargaining issues with the Foxboro Police Department. Upon conclusion of which, we will exit executive session and re-enter open session.
Second.
Pauline, I got it. Again, compliment you. You sit here for hours and you write down this stuff, and then 2 weeks goes by and I nitpick a word. You are really entitled to my a pat on the back, okay? It's getting late, but take it for granted for what you're doing. Thank you.
and Pauline, if you want to drive with me to Suffolk Law tomorrow and apply for 3 credits after this discussion tonight, I think it's appropriate.
I really
We're
take
well
it
on
for
our way
granted,
towards a
and
law
I
degree.
shouldn't. Thank you.
Well, it is
We have to vote.
Administrative Professionals Day tomorrow, so you could
Is it?
All those
say your thanks in a different way to Pauline tomorrow.
all those in favor?
Aye.
Aye. Opposed? None.
Thank
I don't